Well, good afternoon, everyone. It's lovely to be back in court today, but I have to apologise because I'm rushing away after my paper. So lovely it is to be here. I'll be leaving quite quickly afterwards. So I think we've agreed that after my paper, I'll take some questions at that stage. I think that might get everything in place. In my paper today, I want to look at the role that the European Court plays in terms of its ability to impose financial penalties on Member States and the implications that that has for environmental law. Just to link back into something that Margaret said this morning, about 20% of all enforcement cases, that's across the board, concern environmental law. And you can see there from the latest figures, the European Commission had over 700 cases open in 2007 concerning EU environmental law. So that hopefully puts things in context. The reason for putting this last bullet point up was just really to take a slight aside and really just point out the important role that NGOs and individuals have in terms of making complaints about non-implementation or wrong implementation of environmental law. You can see there in that slide that almost a quarter of the enforcement actions opened by the Commission in the area of environmental law in 2007 were the result of a complaint from an individual or an NGO. Now, I suppose, beginning at the very beginning, the European Commission's role in enforcing environmental law is set out in Article 226 of the treaty. And most of us will be familiar with that in terms of poor implementation of directives, either situations in which Member States fail to implement a directive at all, or a situation in which they do so, but the national law fails to meet the objectives of the directive. More recently, however, the Court has begun to concentrate on issues of environmental governance and on failures in environmental governance. If you like, a failure to enforce environmental law at national level. The first case where we saw this was the Commission Ireland case in relation to waste, and Jim mentioned quite a lot of detail in this case this morning, so I'll just skip to the last bullet point here and really just emphasise the point that in this case, at several points in the judgment, the Court refers to there being a general and persistent failure in terms of the implementation of the directive in Ireland. Really what the Court's pointed to here is that proper implementation, or full implementation, will require a more effective enforcement system at national level. If we move on, we can see the same approach being taken in a case that Ronan has just mentioned, Commission against France. In this case, as you can see in the second bullet point here, the Court found that there had been a structural inadequacy in the measures taken by France to enforce EU fishery conservation law. Basically, the issue in this case was that, in the eyes of the Court, France didn't have effective controls over either the catching or the sale of undersized fish. So again, though, the Court pointing to a failure in environmental governance. So, going back to Article 226 and the Commission's initial enforcement action, these are the sorts of issues then that the Court's dealing with. But one thing that's been lacking, or one thing that's been missing in the Court's armoury has been the ability to go back and enforce the judgments that it has put in place. That was very much the case up until 1994, and in that year, the Treaty of European Union introduced what we now know as Article 228, and this began to address that gap. And it's maybe just worth spending a little time looking at how Article 228 looks, or how it works. As you can see, if the European Commission believes a Member State hasn't taken enough action to implement a Court's judgment, well, first of all, and it should say this in Part 1, but it doesn't, first of all, the Commission will enter into informal discussions to try and resolve the issue. But if that doesn't work, the Commission will then issue what's called a reasoned opinion. Now, this is a formal document. It sets out, first of all, what action the Member State should take, but also, secondly, it gives a time period, a time limit within which that should be done. As you can see in point 3, if that doesn't resolve the issue, the Commission then has the power to bring the case back to the court. And on this occasion, perhaps linking back into some of the discussion this morning, you can see that on this occasion, the Commission has the power to suggest to the court the nature of the penalty, the financial penalty that the court should be considering. And finally, in point 4, you can see that the court then has discretion to impose, and this is the wording of the the wording of the treaty. The court has discretion to impose a lump sum or penalty payment. Just looking at how that's applied. Well, first of all, looking at penalty payments, these are basically meant to be persuasive. They're meant to bring the member state into line as soon as possible. And the penalty imposed will run from the date of the judgment in the second, this Article 228 case. Now, this is, I think, where I should fall on my sword. I put here the number of cases to date, 4. Thinking of this morning, I think I've actually counted one case twice. There are actually 3 cases, and I'll mention them as we go along. So here's a confession. Just looking at some examples of this in practice, Margaret this morning mentioned the case of Commission in Greece. This was the first case in which the court actually imposed a periodic penalty. The issue in this case was that in 1992, the court had found Greece to be in breach of the Waste Framework Directive because of the operation of an illegal site on the island of Crete. When this breach continued, or as it carried on, in 2000, the Commission brought a case back before the court, and you can see that on this occasion the court decided that it would deal with this by requiring Greece to pay €20,000 for every day post-judgment until it complied with the initial court judgment. And ultimately, this cost Greece something in the region of €5 million. A second case where the court has applied the penalty order, and again in the context of European environmental law, is Commission against Spain. Now, this was a case which concerned the Bathing Waters Directive. Back in 1998, the court had found that a significant number of Spanish bathing waters didn't meet the standards that the directive required. And again, when this situation perpetuated, the Commission brought Spain back before the court. And you can see that in 2003, the court decided to impose a periodic penalty order. As you can see here, the penalty was going to be over €600,000 per annum for every 1% of Spain's bathing waters that continued to fail to comply. So hopefully you get a sense from that these fines are meant to be persuasive. If we move on just to look at lump sum payments, if penalty payments are meant to be persuasive, lump sum payment orders are basically meant to be punitive. They're intended to penalise the member state for its own bad behaviour and hopefully persuade the member state to, well, essentially not to repeat that situation. As you can see, so far to date, the court has imposed 2, both against France. If we look at the first of these cases, this is the case which Ronan mentioned earlier today. In this case, the court, again as I mentioned earlier on, was concerned with EU fishery conservation law. And here you see again the court imposing quite a hefty periodic penalty, requiring France to pay €316,500 per day for every 6-month period that it continued to fail to comply with the EU provisions. But also in this case, the court decided that it would be appropriate to impose a lump sum order. And you can see that the lump sum imposed was in the sum of €20 million. Now, if I just go back one. There. In this case, the court explains that the purpose of the lump sum penalty, or the reason, if you like, that the court will impose a lump sum penalty, is really to reflect the impact of the member state's conduct on public and private interests across the community. and also to reflect the fact that a breach has persisted for a long time. Now, in the case, the court doesn't actually identify the public or private interests involved, but I think we can probably take a stab at that. We can speculate. I think we can say that there's probably going to be seen to be a general public interest in the conservation of fish stocks. And in terms of the private interest, well, that I think takes account of the private interests of fishermen in other member states across the community and the impact upon them of France's failure to properly implement and enforce European fishery conservation measures. The second issue in this case, obviously then, going back to this idea of the court's rationale for imposing lump sum penalties. Well, in Commission against France, in terms of the breach, the length of time that the breach persisted, well, in this case we were talking about a period of 14 years, so a considerable period. Now, again, going back to what I mentioned earlier on, this was the case in which the court referred to a structural failure in France's enforcement of European fishery conservation laws. Now, in imposing the lump sum penalty order, the court doesn't draw a direct link between that and the structural failure. But if you go back to this test and this idea that a lump sum penalty order will be imposed in situations where the member states' failures impact on public and private interests and there's a lengthy period of non-compliance, this idea of public and private interests being engaged, I think, it's just the type of case that will be engaged where we're talking about a failure in environmental governance. A failure in environmental governance is likely to impact on public and private interests more broadly. Now, if we link that back to the case against Ireland in terms of waste management, Jim mentioned this morning that the Commission, as of yet, wasn't entirely satisfied with the measures Ireland was proposing in terms of waste management enforcement. So obviously, this has implications for Ireland in terms of the use of lump sum penalties where there are failures in environmental governance. If we sort of take a step back and begin to evaluate the use of Article 228, well, as you can see from the first bullet point here, at the end of 2007, there were 77 cases in relation to environmental law where a previous European Court judgment in the eyes of the Commission hadn't been properly implemented, hadn't been properly addressed. At the same time, to date so far, there have only been 2 lump sum penalty orders, and 2 lump sum orders and 3 penalty orders. So I think what that suggests is that actually Article 228 is working, that when the Commission comes calling, Member States are actually then reacting and they are coming into line. However, the quotation in the second bullet point does suggest an ongoing problem. And this is the fact that Member States essentially are dragging their heels, that they will delay implementation, compliance with the Court's judgment for as long as possible. And obviously in the environmental sector, that means that the non-compliance with the particular environmental law continues throughout that period. Just give you a few examples of that in practice. European Commission against Germany is one example. In 2003, the European Commission brought Germany before the court, essentially in relation to a public procurement contract, a contract concerning the development of a waste treatment works. Now, in this case, Germany didn't comply with the court's judgment. So the European Commission began Article 228 proceedings. The Commission's reasoned opinion deadline ended on the 1st of June 2004. By that stage, Germany hadn't complied. The Commission then opened an Article 228 case, and actually, as you can see here, in February 2005, Germany notified the Commission of sufficient measures to comply with the previous judgment. As you can see, that was almost a year after the closure of the reasoned opinion, and it was about 5 months before the case finally came to judgment. But in this case, given all those facts, the court decided that no financial penalty should be imposed on Germany. Let's look at why. Well, firstly, the court finds that actually, yes, there's a technical breach of Article 228, that Germany had failed to comply by the end of the period prescribed in the reasoned opinion. But ultimately, the court decides that no penalty payment should be imposed. The reason for this is that penalty payments are intended to run from the date of the court's judgment under Article 228, and they're intended to bring the member state into line as soon as possible. So in this case, because by that date Germany had finally come into line, the court decides that a penalty payment isn't appropriate. So although in this case there had been a period of 2 years delay between the court's initial judgment and Germany actually getting round to implementing the measures necessary to comply, the court decides that no penalty should be imposed. See a very similar issue in Commission against Italy a year later, in 2006. In this case, although 3 years elapsed between the court's initial judgment and the date on which Italy finally complied with the court's requirements, again, no financial penalty is imposed. So you can see that what these cases are suggesting is that member states can delay, but as long as they take the necessary action before the Article 228 case comes before the court, no financial penalty is imposed. Now, to deal with that problem, the European Commission in 2005 decided to introduce a new enforcement strategy. What they said was that as part of the strategy, from the 1st of January 2006, in every application that the European Commission makes under Article 228, it will ask the court to impose 2 financial penalties. First of all, it will ask the court to impose a periodic penalty based upon the member state's delay in implementing the Article 228 judgment. Now, that, in a sense, is a continuation of the Commission's existing practice. But secondly, the Commission has signalled that it will also ask the court to impose a lump sum penalty, and that lump sum penalty will be calculated on the basis of the delay that the member state has caused, or the delay the member state has actually had in implementing the court's initial judgment. So the idea here is that member states should no longer be able to delay the implementation of court judgments and also then escape financial penalties. The first case testing this came before the court just before Christmas. The case essentially concerned France's failure to implement the directive on the deliberate release of GMOs. Now, France had been brought before the court in 2004, and the court had directed France to take measures to implement the directive, but that hadn't happened. And you can see here from the Advocate General's report that it was commonly agreed that by the end of the Commission's reasoned opinion in its Article 228 application, again, France hadn't taken the requisite measures. However, when the Commission's Article 228 application came before the court, by that time, belatedly, France had adopted the measures necessary to implement the directive. Now, going back to the previous cases, the case against Germany and the case against Italy, that would have meant that the court wouldn't impose a penalty. But in this case, the Commission then essentially launched this Plan B. It asked the court to impose a lump sum to penalise France for the delay that had happened in terms of the implementation of the directive. The reaction the court took to the Commission's strategy in this case was, first of all, the court said that the Commission guidelines on enforcement were just that. They're just guidelines. But secondly, the Court was generally critical. It was critical of the idea that the Commission, well, in its eyes, should automatically be asking the Court to impose lump sum penalties in this way. The Court instead emphasises that lump sum penalties are a discretionary measure for the Court to decide, and it refers back to its judgment in the previous Commission France case, where it says that in exercising that discretion, the Court will take account of issues like the length of delay and also the impact of the Member States' actions on public and private interests. Having said that, in this particular case, in terms of the implementation of this directive, the Court first of all accepts that, well, the Court first of all notices that in terms of France's failure to implement the directive, that there was no reasonable excuse for this ongoing delay. It also notes that actually France's non-implementation of this particular directive was only part of a general pattern of non-implementation of GMO directives within France. And the Court here says that such repeated unlawful conduct in any sector of European law is such to be likely to attract the imposition of a lump sum penalty. Now, going back to what I said earlier, that seems again to suggest a suggestion that the Court will see lump sum penalties as being an appropriate way to deter or to penalise cases of defective environmental governance. More specifically, however, and perhaps more of direct interest to us, is that the Court also went on to say in this case that where a failure to comply with a previous court judgment was likely to cause harm to the environment and human health, then that breach would be regarded as being significant. Now, that suggests then that the Court will support the use of lump sum penalties to penalise Member States for delays in the implementation of European Court judgments in the area of environmental law. If we contrast the facts of this case, in terms of the delay in implementation and the fact that just prior to the case coming to court, France belatedly implements the necessary measures to transpose the directive. It's very similar to commissioning against Germany and commissioning against Italy. Yet we saw in those cases, those member states escaped financial penalties. As you can see here, in this case, the court imposed a €10 million lump sum penalty on France. So you can see that there has been a change in the way in which the laws are applied. Finally, where do we go from here? Well, however you judge Article 228, whether you judge it as a success or a failure, there's one concern I have which still remains, and that's the length of time it's taking to actually go through the enforcement procedure. At present, the average time span between the opening of a Commission's initial enforcement action under Article 226 and the Court's judgment under Article 228 is 10 years. And during that time period, obviously, the non-implementation of the directive, the non-application of European environmental law continues. One suggestion, or one proposal I should say, that's been made, which is part of the Lisbon Treaty, is that where a Commission enforcement action is concerned with the failure to transpose a directive into national law, then as part of the initial Article 226 enforcement action, the European Court at that first stage should have the power to impose financial penalties. That obviously will only apply in terms of failure to transpose directives. In terms of other breaches or other failures to comply with European Court judgments, we'll just have to see how effective the new Commission strategy is. I think on that point I'll conclude. Thank you.
Just stay where you are there for a second, Ronan. Brian, sorry to rush you.
Okay.
Not that we charge you for going over time, but your taxi driver may well have his meter running outside.
That's right.
And he'll be charging you. So, any questions for Brian before he heads away? We have one down here in the front, in the middle, yeah? Okay.
Aye.
1 second now, Doctor, just hold on a second there. Let me just get the microphone to you.
Hi, Uwe Hild again, Irish Doctors Environmental Association. I am full of admiration for you people in the legal profession for the time that you take to go through all these hoops. At the very, very latest, the tipping point for climate change is going to be reached within the next 5 to 10 years. Have we any hope? And is there anything you could do to speed up the implementation of stuff that is vital, not only for us, but for our kids, the planet,
Just a small question for you there. Yeah.
What time was that taxi again? Yes, you're perfectly right. That's an issue. I mean, as I say, if the average time that it takes, to bring an Article 228 case before the court is 10 years after the Commission began its initial enforcement action, then obviously there's a problem. So, hopefully that's one issue that the amendment in the Treaty of Lisbon may begin to address. But yes, I accept it's only beginning to address that problem, and it's part of, as you said, a larger problem. So yes, I accept that there is a failing there.